Good afternoon, everyone, and welcome to this Tiliki and Gepin's webinar entitled What to Expect from Myanmar's New Insolvency Law. My name is Nada Songsasen, and I will be your moderator this afternoon. Before we begin, a little housekeeping for the webinar. Firstly, we gladly welcome your questions and invite you to write them in the Q&A box on the right side of your screen at any time during the session. As we have a large number of attendees today, all of you have been placed on mute, and our speakers will address questions during the Q&A session at the end of the presentation. Should you have any issues with the software, you can also type them here, and our IT team will be on hand to assist you. Secondly, our marketing team will make the PowerPoint slides available to you after the session via email. You are also welcome to contact them or the speakers with any further queries that you might have when the session has ended. With that out of the way, it is now my privilege to introduce our distinguished speakers today, who will provide an overview of corporate insolvency and rehabilitation under Myanmar's Insolvency Law 2020 and Insolvency Rules 2020. They will also lead attendees through relevant procedures for both debtors and creditors, and discuss the requirements and consequences of winding up a company in Myanmar. Dr. Ross Taylor is a counsel in Tiliki and Gibbons corporate and commercial team in Yangon. With nearly 2 decades of experience in Southeast Asia, Lord is widely recognized as a leading figure in the legal scene in Myanmar, and is ranked as one of the country's top lawyers by IFLR 1000. U is a senior attorney at law in the firm's Myanmar office, with particular experience in corporate and commercial, as well as dispute resolution and litigation. Based on his client service and in-depth understanding of local legislation, he is recognized as a leading lawyer in Myanmar by Asia Law Leading Lawyers. And with that, I now turn it over to Dr. Ross and Une.
Good afternoon, everyone. Welcome to our webinar on the new insolvency law. February the 14th this year was a very romantic day in Myanmar. Not only was it Valentine's Day, but the new insolvency law was passed. And the parliament in Myanmar may have had an inkling of what was to come. Shortly afterwards, we've all been suffering from COVID problems, and companies in Myanmar, like everywhere, have been suffering. And so it couldn't really be a better time to introduce a new insolvency law and new insolvency regime in Myanmar. The law is a very large law. It's about 200 pages long, and there are about 100 pages of rules to accompany the law. So we'll try and do our best to simplify and clarify what we can in the law today. So firstly, looking at the major sections of the law, Part 3 of the law deals with the regulation of insolvency practitioners. And in order to be, for example, a rehabilitation manager under the law, someone must be qualified as an insolvency practitioner now. This creates a complication because the council has been established recently to approve insolvency practitioners. But as far as we're aware, no insolvency practitioners have been approved as of today. Next part of the law, important part, is receivership, Part 4. Part 5 deals with corporate rescue and rehabilitation. Part 6 is addressing a new area of micro and small and medium enterprise insolvency. Part 7 deals with winding up. Part 8 deals with personal insolvency or bankruptcy. And Part 10, another new aspect of the law, is cross-border insolvency. Although, as we understand it, that requires a presidential notification that has not yet been issued. But today, because of the size of the law, we have decided that we'll focus on corporate rescue and rehabilitation, and then what follows if rescue fails, winding up. So we'll be focusing on those two areas of the law today. So dealing with rehabilitation, there are two stages that the law describes for rehabilitation. Firstly, the rescue stage, and then the plan stage. At the rescue stage, then options are explored, and there will be a decision on the future of the company. And then once a plan is approved, it moves into the plan stage, and the rehabilitation plan is implemented. So there are those two stages, and during those two stages, excuse me, the company is protected. So starting to talk about the first of those two stages, the rescue stage, the application for rehabilitation may be made to the court by the company on a resolution of the directors, the liquidator of the company, one or more directors of the company, one or more creditors of the company, including a secured creditor, or any combination of those people or entities. The court may make a number of orders on a rehabilitation hearing. The order that the applicant presumably wants is the first order, an order appointing a rehabilitation manager, but the court might also dismiss the application. Thirdly, the court may adjourn the hearing on conditions or without conditions. Anyone familiar with Myanmar court proceedings knows that Myanmar courts frequently adjourn hearings on conditions. Fourthly, the court might actually treat the application as a winding up petition and make any order that the court would in that case. So the court might actually appoint a liquidator, or the court may make an interim order. So what are the circumstances when the court might make a rehabilitation order? The court may make a rehabilitation order if the company is unable to pay or unlikely to be able to pay its debts as and when they become payable. And there also must be reasonable prospects that one of the following can be achieved. Firstly, most importantly, rescuing the company as a going concern. Then realistically, if that is not possible, ensuring as much as possible of the business continues. And then finally, if neither of those are possible, achieving a better result for creditors than if the company were wound up immediately. The rehabilitation manager may be appointed by the court in the process I've just described, or may be appointed by the company directly or a secured creditor. Once the rehabilitation manager is appointed, however, then the rehabilitation manager must notify the company, must notify the registrar, which is the registrar of the DICA, and all known creditors. The rehabilitation manager then takes control of all the company property, investigates the viability of the proposed plan, and controls the business, and, excuse me, may in fact sell all or part of the business. So the powers of the rehabilitation manager are extremely wide. As I've indicated, the company is protected during the rescue stage. By law, no step may be taken to enforce security over company property without leave of the court or consent of the rehabilitation manager. Court proceedings, actions, or arbitration may not be brought against the company without leave of the court, If anyone tries to dispose of company property that is void without the consent of the rehabilitation manager unless the court orders, any attachment or execution or similar proceedings against company property is void, and any transfer of shares made without the consent of the rehabilitation manager is also void. There are stringent publicity requirements in the rescue stage and actually in the plan stage that I'll explain later on. Every invoice or order or letter must state that the company is in rehabilitation. And this must also go on the company's websites. Turning to look at the position of creditors, they may appoint a creditors committee to consult with the rehabilitation manager. The court may make an order, or the rehabilitation manager may allow the creditors to inspect the company's books to check the finances. And most importantly, the rehabilitation manager must convene a first meeting of creditors within 30 days of appointment. And if a rehabilitation plan is ready, which may be a little unlikely within 30 days, but if one is ready, then that meeting would consider approving the rehabilitation plan. If not, if that rehabilitation plan is not ready, there must be a meeting within 3 months to consider the plan. The plan basically includes what you might expect: the identity of the plan supervisor, the extent of compromise of creditor claims, nature and duration of any moratorium, extent to which the company is to be released from its debts, the order in which distributions amongst creditors are to be made, any claims of secured creditors who would be affected, and other key details. There's an interesting approval process, which is a kind of double majority, or it's a simple majority relating to value of claims of creditors voting at the meeting, but also total number of creditors voting at the meeting. And the plan will come into effect, if it's approved by the creditors, when the rehabilitation manager prepares a formal document recording the plan's terms. The document is signed on behalf of the company and also signed by the proposed plan supervisor. So that is the first stage of the rehabilitation proceedings, and they conclude on the signing of the plan. So moving on to the second stage, the plan stage. The effect of the rehabilitation plan is that it binds all creditors. Secured creditors may still realize or otherwise deal with their secured property unless the plan provides for them and they voted for it. Similarly, with owners or lessors of land, if they voted to adopt the plan and it provides for them, then they can't deal with their property. It also binds the company's officers, and the shareholders. So a court may make particular orders ordering a secured creditor not to deal with its security interest, or ordering an owner or lessor of property not to deal with its property. Again, as I indicated before, in the plan stage, there must be a statement that the company is subject to a rehabilitation plan, and that must be contained on every invoice, order for goods or services, or business letters, and all the websites. There's either good news or bad news on the termination of the plan. Either the objective is achieved and the plan has been successful, or if the objective is not being achieved, then the company transitions to a winding up. And my good friend and colleague will in a few moments explain about winding up procedure. But first, I'd like to talk about some of the technological innovations in the law and the rules. This is a thoroughly modern law, and it deals with things like electronic delivery of documents, websites, and remote attendance at meetings. So, under Rule 11 of the Insolvency rules, documents may be delivered by electronic means. So that is a good innovation. Another one is that websites may be used to deliver documents. So documents can be downloaded from websites instead of them being delivered to the individuals concerned. So unless the law requires personal delivery, then the office holder, for example, the rehabilitation manager, can deliver a notice to people, for example, creditors, saying that future documents will be available for viewing and downloading on a website without notice. And documents will not be delivered to the individuals unless so requested. And the notice must also specify contact details if the individual is old-fashioned like me and would prefer a hard copy. Websites can inform the public about the rehabilitation proceedings, as I've already indicated. So the law and the rules deal with the disbursement of information through websites. Extremely importantly, remote attendance at meetings. I'm sure that many of you will be aware of the current rehabilitation proceedings or insolvency proceedings in relation to Thai Airways at the moment. And as I understand it, a new decree has had to be issued in order to allow remote attendance at meetings. In Myanmar, this is not the case. It's in the existing rules, Rule 20, that any meeting may be held in a way that persons not present together at the same place may attend it. There are conditions, however, as you would expect, that the attendees must be able to speak and vote at the meeting. So on Zoom, for example, they must be able to speak, and there must be a mechanism, a voting mechanism. There must also, and not surprisingly, be arrangements to actually identify those attending the meeting and for the security of the meeting by electronic means. And the notice of the meeting must actually state how people can access the meeting remotely. So now, as I indicated before, my good friend and colleague Unwei U will explain the winding up under the new insolvency law.
Sorry, I just recognized my mic is mute. Thank you for Dr. Ross for the comprehensive presentation on the rehabilitation of the companies. And good afternoon, everybody, and nice to be meeting with you. For me, I have to discuss about the winding up of the companies in Myanmar. as discussed earlier by the Dr. Ross, if the companies fail for the rehabilitation or rescue or planning stage, then the companies tend to be winding up under the insolvency law. Or if the company is solvent, then the company have to wind up by voluntary or by the consent of the creditor. So for the companies that apply under the insolvency law must be the registered company under the Myanmar Companies Law and other body corporates that register under the Myanmar Company laws in accordance with the provision of the Myanmar Companies Law. So for the wider matters, there are two options for the companies. One option is voluntary winding up, and another one is the winding up by the supervision of the court. So for the option of the voluntary winding up, there are also two options available. One is the members voluntary winding up, and another one is creditors voluntary winding up. There are two distinctions between the members voluntary winding up and the creditors voluntary winding up. When the company is proposed to be winding up, the directors of the companies must explore all the affairs of the company and then prepare a statement we call solvency report. Must prepare this solvency report that the company is solvent and able to pay all the debts within 1 year from the date of the commencement of the winding up. Then the report register with the insolvency registrar. This is the we call DICA, Directorate of Investment and Company Administration in Myanmar, the company registrar. The DICA is also, according to the law, DICA is also the insolvency registrar. So registrar with the insolvency registrar on the solvency report, and then try to call a general meeting for all the members. And at the general meeting, try to present and lead the statement to the members that the company is proposed to be wind up, and then especially for the members voluntary winding up, the most important is, as I discussed earlier, the solvency report. So at the general meeting, the members agree for the members voluntary winding up, then the general must approve or appoint a liquidator to proceed all the winding up process of the company. Even the winding up process intended for the members voluntary winding up, there will become to be creditors voluntary winding up, because during the winding up process, if the liquidator found that the company is insolvent, then the liquidator must prepare a report and call the meeting for the creditors. And at the creditors meeting, the liquidator present the and lead of the statement about the insolvency of the company. Then at the creditors meeting, the creditors can agree for the winding up of the company by the creditors as their creditors voluntary winding up. Next slide, please. So, as discussed earlier, there are two options to become to the creditors problem winding up. One, when the writers of the company call the meeting to the creditors along with the company's meeting to propose to be winding up, and at the same time call the creditors meeting and present a report to the creditors about the proposed winding up, and if the creditors agree to proceed on the winding up process, the creditors or the company must appoint the liquidator to process for the liquidation. So at this stage, there will be directly making of the direct call of the writers to be the creditors voluntary winded at all. Another one is the this is the coming from the report of the liquidator on the members voluntary winded at. Anyhow, if the creditors agree for the winding at, then they have to appoint a liquidator or more than one liquidator to process on the creditors voluntary winding at. Next slide, please. So for the option of the winding up, and also the if there is not possible for the members voluntary winding at or the creditors voluntary winding at, and the company is insolvent, one of the writer or the creditor of the company can apply to the court for the winding up by the supervision of the court. To apply for the winding up by the court, the companies must make a special resolution that company has to be wound up by the court, or the writers of the company or the creditors thinks if the company is insolvent and cannot be debt to the creditors and other debtors, and after the application and the court is certified that the company should be wound up, and the court think fit, then the court can order to the company to be wound up, and also any other grounds that appear to be wound up the company by the court. So for the winding up process by the court has very wide power to make the decision about the application of the winding up process. This the court can appoint liquidator, or the court can order to liquidate the company, or the court can dismiss the petition of the application. So for the other ground of the liquidation that the court thinks fit is that if the company is ongoing the business without the interest of the people or interest of the members of the company, and if the court found the company is misleading the debtors, the creditors, then the court can order the company to be wounded. Next slide, please. So every winding up process winding up by the members, winding up by the creditors, winding up by the supervision of the court, there must be appointed a liquidator, one liquidator or one or more liquidator. So there are three types of the liquidator. One is the appointed by the company, or another one is appointed by the creditor, or another one is the liquidator appointed by the court. Anyhow, if the liquidator is appointed to the company, the liquidator take control or on the business of the company. So after appointment of the liquidator, the company sees all the business that except for the purpose of the winding up process, and there are no business operation or no proceeding or no legal proceeding or arbitration against the company. And if there's something wishes to take something action on legal action or the arbitration, there must be taken the approval of the court, and all the action against the company without the leave of the court shall not be proceed. And after appointment of the liquidator, for the disposition of the property of the company, there must be seek for the consent of the liquidator, and if there is no consent of the liquidator and the any disposition of the company property without the consent of liquidator is void and useless. So during the liquidation process, or the transfer of the shares, transfer of the company properties, and other transfer must be in accordance with the under the function and duties of the liquidator, and only the liquidator has the right to transfer, dispose, and take action against other debtors or creditors against the company. And this is the vested right of the liquidator for the company that winding up. Next slide, please. So during the liquidation process, the liquidator must collect all the debt receivable by the company, and collect all the movable or immovable properties of the companies, and then all the liquidator must arrange these assets and other cash or non-cash properties, and then distribute all the collected properties to other person that are receivable from the companies. So when distributing to the receivable person, the liquidator must distribute and the priority orders. First, the liquidator must appropriate for the expense of the insolvency practitioner. And if the insolvency practitioner is appointed by court, then the legal cost of that insolvency practitioner For the next step, the remuneration of the insolvency practitioner, and then salary that owed to the employees before the liquidation process, and next, that other amounts that has to pay to the employees, and next, any severance entitlement that has to pay to the employees, and then any compensation for any injury suffered by the employees, and if there's the any debts or costs that incur during the rehabilitation process, they has to pay, and finally, tax prescribed by the rules of the insolvency. So especially the debts prescribed by the rules currently is the dividend that has to be paid to the shareholder of the company. So at present, we are for the upcoming solvency practice, we have to go in accordance with the insolvency law, and previously we have to use the provision of the Myanmar Companies Law. Now the authorities added the insolvency law as the unified code of the all insolvency matters, and the insolvency law, Myanmar Insolvency Law 2020, start effect from the date of the March 26, 2020, and at the same day, there's the council called the Insolvency Practitioner Supervision Council already established. But at present, as far as we know, we are not able to register as the insolvency practitioner with the council, but the insolvency registrar, Tiger, confirmed that all the upcoming insolvency practice, especially for the company to the liquid winding up process, has to be done in accordance with the Insolvency Law 2020. So this is all my discussion about the winding up process under the Insolvency Law 2020, and now we are inviting all the people for if you have any question on this presentation. Thank you, Konara.
Yes, thank you both for the clear and informative presentation. At this point of the webinar, we will now transition into the Q&A session. During this section, please feel free to continue submitting your question through the Q&A box on the right-hand side of your screen. So I will go through with the first question. For the first question, is there a mechanism to amend the rehabilitation plan prior to winding up? So I will turn to Dr. Ross to answer this.
Thank you. Yes, that's a really good question. The answer to that is fairly short. Yes, there is a mechanism to amend the plan after it's been approved. This would require a further vote of the creditors.
All right, so I will go with the second question. The second question is whether or not is the timeline given in the rehabilitation plan to be followed strictly. For example, if company fails to complete process within deadline. Okay, I will turn to Dr. Ross to answer this.
Yes, I believe the timeline is intended to be followed strictly. The timelines that are given under the law, I believe, can be varied by the court. So timelines in the rehabilitation plan, I think, would take amendment to the plan. Timelines in the court, for example, the 3-month timeline, I think would require a court order for amendment. Do you agree with that, Nguyen U?
Oh, yes. All the rehabilitation process, rescue and the planning has to apply to the court about the plan stage and also the rescue stage, and all the time extension has to get approval with the court by the rehabilitation manager, or yes, especially the rehabilitation manager.
Yes, thank you.
We have a few more questions regarding corporate rescue and rehabilitation. Whether the insolvency law is allowed the company to choose freely between rehabilitation process and directly filing for winding up, or subject to the court's discretion under the assessment of the court?
I think that would depend on the decision of the court. If the company applies for, if the company appoints a rehabilitation manager, then the rehabilitation manager would already be appointed. So if the application is made to the court to appoint the rehabilitation manager, then it would be up to the court. So I'm not, I hope that answers the question.
Uneu, do you have any additional answers that you want to provide on this?
Yeah, especially to go directly for the winded up or to apply for the rehabilitation depends on the company's solvency test. If the company is solvent and the court think fit that the companies can going for ongoing concern, then the court can order for the rehabilitation process and appointment of the rehabilitation manager. But if the court found that the company is insolvent and cannot process for the rehabilitation, then there will be the winding up by the court. But actually, this is mainly depends on the situation of the company and the nature of the applying for the winding up or the rehabilitation. This is to be considered based on the situation of the company by the court.
Okay, thank you for the answer. For the next question, what is the difference between winding up under Myanmar company law and winding up provisions under Myanmar insolvency law? So I will turn this question to Uneu.
Okay, let's start from the early and admit. Before the Myanmar Companies Law 2017 and Myanmar Insolvency Law 2020, we have the another law, that the Rangoon Insolvency Act 1909 and the Myanmar Insolvency Act 1920, and also the Myanmar Companies Act 1914. So these are the century-old legal provision. And under the Rangoon Insolvency Act and the Myanmar Insolvency Act, this only provide for the personal insolvency or bankruptcy, and for the company winding up, we have to apply the provision of the Myanmar Companies Act 1914. But later, the amendment of the Myanmar Companies Law 2017, we have to use all the winders matter under the provision of the Myanmar Companies Law 2017. But later on, the authorities added the Insolvency Law 2020 as the unified code for all the insolvency matters. That's why after the enactment of the Insolvency Law 2020 on February, the only over 1 month, the company, President of the Myanmar issued the notification that the the Myanmar Insolvency Law 2020 start into force on the 26 March 2020. So, what is the difference between the winding up process under the Myanmar Companies Law and the Insolvency Law is the different practice. I mean different practice under the different law, because according to the Insolvency Law 2020, when it's the effect, all the insolvency matter must practice in accordance with the insolvency law. So for the company winding up matter, first we have to apply under the provision of the Myanmar Companies Act, then Myanmar Companies Law. But now, after the March 2020, we have to apply all the company winding up matter under the provision of the Myanmar Insolvency Law. Yes.
Okay. Thank you for answering this. So I will go through the last question. Regarding the winding up of a company, is there any requirement of the members or shareholders' approval for the voluntary winding up, or only directors' approval? So I will turn to Uneu to answer this.
Yes. For the voluntary winding up, it is. I think this question mainly concerned with the members' voluntary winding up. So, for the members' voluntary winding up, first, the directors must explore all the business of the company affairs, and then, if they find that the company is solvent and able to pay the debts within 1 year from the commencement of the winding up, then they have to prepare the solvency report and register with the solvency registrar, and then call the meeting of the members, thus means shareholder meeting, general meeting, and present, submit this solvency report, and also propose for the company winding up. If the company members, shareholders agree on this solvency report and the proposal of winding up by the winding up proposal by the directors, then a company can proceed for the winding up process. So for the members voluntary winding up, the directors of the companies first initiate for the solvency debt, and then call the shareholder meeting and get the approval to proceed the winding up process. And at the general meeting, the members of the or shareholders of the companies must appoint the liquidator. So for this question, the directors of the company and shareholders of the companies must involve step by step at the members voluntary winding up process. Thank you.
Okay, thank you for the answer. So I believe that we have no further questions. Thank you both very much. Do you have any final advice or thoughts for our attendees?
Yes, I have final thoughts, really, not so much advice. I think the Myanmar government is to be congratulated with modernizing its insolvency law and rules. It's to be congratulated for liberalizing the insurance industry, the banking industry, updating the intellectual property laws, And this new insolvency law continues this progress in that direction.
Thank you, Dr. Ross. And with that, the session is come to its end. Thank you to all in attendance for joining us this afternoon. We will be sending a follow-up email shortly that includes the PowerPoint slides from today's session, along with a short feedback form. We would really appreciate if you could take the time to complete the questionnaire so we can continue to develop these online sessions. Thank you and see you next time.